The morning was quiet in the Shenandoah Valley. Raymond was 67 years old, a retired machinist who had spent 40 years building precision parts for the aerospace industry. He owned 3 firearms that he had inherited from his father and grandfather. He kept them in a certified safe, locked and stored exactly the way the law required. He had never been in trouble with the law a single day in his life. He volunteered at the local food bank every Saturday. He coached youth baseball for 15 years. He was the kind of man other men pointed their children toward as an example. But on a Tuesday morning in March, Raymond found a letter in his mailbox that made his blood turn to ice. The Department of Justice was sending a formal notice to Virginia gun owners. The letter referenced a new enforcement protocol that had been approved by the Supreme Court. Raymond had done everything right, followed every rule, paid every fee, and now the DOJ was telling him he had 90 days to surrender one of his firearms or face criminal prosecution. The letter did not explain why. It did not cite a specific crime he had committed. It simply said that the firearm in question fell under a new classification that the DOJ had quietly announced the previous month. Raymond had never heard about the announcement. No one had told him. The media had not covered it. The state of Virginia had not sent a notification. He was expected to somehow know about a rule change that had been hidden in plain sight. This is happening right now to gun owners across Virginia. The DOJ has issued a major announcement that changes everything, and the Supreme Court has already ruled on it. But most people have no idea this is happening because the story is being buried by the news cycle. I am going to break down exactly what the DOJ announced, what the Supreme Court said about it, and most importantly, what you need to do right now to protect yourself and your family. Subscribe to this channel immediately because the next few minutes could determine whether you keep your firearms or lose them forever. Knowing this information 24 hours too late is the same as not knowing it at all. The system is moving faster than most people realize, and you need to be part of the notification squad if you want to stay ahead of what is coming. Let me take you inside what actually happened, because this story has layers that the mainstream media does not want you to see. The DOJ issued its announcement in the Federal Register, which is the official publication where the government puts rules that it wants to slip past public attention. In plain English, that means they put it in a place where almost nobody looks on a day when they knew other major news would be competing for coverage. The announcement was 47 pages long, and buried on page 31 was a reclassification of certain semi-automatic firearms that effectively made them illegal to own in states that had not opted out of the federal program. Virginia had not opted out. In fact, Virginia had recently passed its own set of gun control laws that aligned with the federal guidelines. That alignment meant that Raymond and thousands of other law-abiding gun owners in Virginia were now technically in possession of firearms that the DOJ had reclassified without any vote, without any public debate, and without any notification to the people who owned them. The Supreme Court had ruled on this exact issue just 6 months earlier in a case called Whitfield versus McLean. The ruling was 7-2, which is significant because it shows that even some liberal justices understood the danger of what the DOJ was doing. The majority opinion stated clearly that executive agencies cannot reclassify items that are protected by the Constitution without explicit authorization from Congress. In plain English, that means the DOJ cannot wake up one morning and decide that your legally purchased firearm is now illegal just because they want to. That power belongs to Congress, not to a bureaucratic agency in Washington. But here is the trapdoor that gun control states did not see coming. The DOJ announcement in the Federal Register did not call it a reclassification. They called it a clarification of existing law. In plain English, that means they pretended that they were not changing anything, just explaining what the law already meant. The Supreme Court ruling said this trick is not allowed. Agencies cannot use linguistic games to bypass the constitutional process. But the DOJ is still implementing the announcement anyway, which means gun owners in Virginia are caught in the middle of a battle between the Supreme Court and the Department of Justice. If you are just joining us, hit that subscribe button right now before you finish this sentence. This information is too important to miss, and future updates about this situation could arrive at any moment. Now, I want to explain the hidden danger in what the DOJ did, because this is where most people are going to get caught. The announcement creates a retroactive problem. Raymond bought his firearm in 2019. It was completely legal at the time of purchase. He registered it with the state as required. He completed the background check as required. He paid the transfer fee as required. He did everything a model citizen does when purchasing a firearm. But now, 5 years later, the DOJ is telling him that the firearm he purchased legally is now classified differently, and he has 90 days to either surrender it or become a criminal. In plain English, that means the government is changing the rules after the game has already been played. They are applying a new definition to something Raymond already owned and had already disclosed to the government. There is a constitutional principle called ex post facto that specifically prohibits this kind of government overreach. In plain English, that means the government cannot make something illegal after you have already done it. You cannot be punished for something that was legal when you did it. The Supreme Court has upheld this principle for over 200 years. But the DOJ is arguing that this is not an ex post facto situation because they are not punishing Raymond for anything. They are simply telling him that going forward, he cannot continue to own the firearm. They are calling it a regulatory requirement, not a criminal penalty. This argument is what gun control states are now testing in federal court. And the Supreme Court has already given a preview of how they will rule on it. Here is what is actually on page 16 of the Whitfield versus McLean ruling. The court wrote that when an agency action imposes a significant burden on a constitutionally protected activity, that action must go through the full legislative process and cannot be implemented through an agency announcement in the Federal Register. The court specifically named the Second Amendment as an activity that receives this heightened protection. This means the DOJ announcement is almost certainly unconstitutional, but it is still being enforced right now, which means you are the one who has to navigate this minefield while the courts catch up. If you know anyone in Virginia who owns a firearm, you need to share this video with them right now. Do it while you are watching this. Send them the link. Make a phone call. But first, make sure you are subscribed so you can send them our future updates too. This information is only useful if it reaches the people who need it before it is too late. I am going to give you the exact steps to take right now if you live in Virginia or any state that has similar gun control laws on the books. These steps are drawn directly from what constitutional lawyers are advising their clients in cases that are active in federal court right now. This is not speculation. This is what is actually working for people who are fighting the DOJ announcement. The first step is to document everything you own. Take photographs of every firearm in your collection. Write down the serial number, the make, the model, and the date you purchased each one. Keep copies of all your purchase receipts, all your registration forms, and all your training certificates. In plain English, that means build a paper trail that proves you own these items legally and that you have always followed the rules. This documentation will be essential if the DOJ tries to come after you. The burden of proof is going to be on you to show that your firearms were legally purchased, and you want that evidence ready before you ever need it. The second step is to send a formal letter to your state representative and your senator. Tell them that you are aware of the DOJ announcement and that you expect the state to file a challenge to protect its residents. In plain English, that means make some noise. The government pays attention when enough people complain. If you do not say anything, they assume you do not care. They assume you do not know. They assume you will just comply without a fight. Prove them wrong. The third step is to join or form a local firearms rights organization in your area. These organizations have lawyers on staff who are tracking these cases and who can advise you on what to do in your specific situation. In plain English, that means do not try to fight the DOJ by yourself. Get help from people who have been fighting these battles for years and who know how the system works. The fourth step is to make copies of the DOJ announcement and the Supreme Court ruling. Keep them with your firearms documentation. If an officer ever stops you or asks about your firearms, you will have the documentation to show that you are aware of the legal situation and that you are following the advice of constitutional attorneys. In plain English, that means do not be silent. Do not just say, "I do not know." Show them that you are educated about your rights and that you have a legal strategy in place. The fifth step is to never, under any circumstances, voluntarily surrender a firearm to the government unless you are specifically ordered to do so by a court order signed by a judge. In plain English, that means do not give up your property just because a letter tells you to. A letter is not a court order. A letter cannot send you to prison. Only a court can do that, and a court must give you due process first. These 5 steps are your shield right now. They will not guarantee that nothing bad happens to you, but they will put you in the strongest possible position to fight back if the DOJ tries to enforce this announcement in your state. Let me tell you what is coming next, because the DOJ announcement is just the beginning of a much larger battle that is going to play out over the next 2 years. The Supreme Court ruling that I mentioned earlier is going to be cited in dozens of cases across the country. Gun control states are already designing new laws that try to work around what the court said. They are not going to stop just because the Supreme Court told them they cannot use certain tactics. They are going to try different tactics that achieve the same result. Here is what to watch for in Virginia specifically. The state legislature is already considering a bill that would require all semi-automatic firearms to be registered in a state database that is accessible to federal agencies. The bill is being marketed as a public safety measure, but it is really designed to create a de facto registry that the DOJ can use to identify and target gun owners who do not comply with the announcement. The Supreme Court has said that registries of constitutionally protected activity are suspect, but that does not stop states from passing the laws and then daring someone to challenge them. In plain English, that means the fight is going to move from the federal level to the state level and back again in an endless cycle. Every time the courts strike down one approach, the gun control advocates will design another one that achieves the same result through different means. The only way to stay ahead of this cycle is to have a notification system that tells you when the rules are changing. That is what this channel provides. Every time a new law is proposed, every time a federal agency issues an announcement, every time a court rules on an issue that affects your Second Amendment rights, we break it down in plain English and give you the exact steps to protect yourself. We do the research so you do not have to spend 40 hours reading legal documents that nobody else is going to explain to you. Subscribe right now. Do not wait until after something bad has happened. The time to prepare is before the crisis, not during it. I want to bring this home with a story that happened in Fairfax County last month. A woman named Patricia was a retired teacher who had inherited her late husband's deer rifle. It was a single-shot bolt-action rifle that had been in their family for 3 generations. She kept it in a locked case in her bedroom closet. She had registered it with the state when her husband passed away, as the law required. She was doing everything by the book. Then the DOJ announcement went into effect. The rifle that Patricia had registered legally was reclassified as an antique firearm that required special handling under federal law. The state of Virginia sent her a letter telling her that she had to either surrender the rifle to a federal agent or sell it to a licensed dealer within 60 days. Patricia did not know what to do. She could not afford to hire a lawyer. She did not know who to ask for help. This is where the Supreme Court ruling becomes relevant. Patricia found a nonprofit organization that provides free legal assistance to gun owners who are facing exactly this kind of government overreach. The organization filed a federal lawsuit on her behalf, citing the Whitfield versus McLean decision and arguing that the DOJ announcement was an unconstitutional agency action that imposed a substantial burden on her Second Amendment rights. The case is still pending, but the judge has already issued a preliminary injunction that prevents the DOJ from enforcing the announcement against Patricia while the case is being heard. That ruling bought Patricia time. It bought her the chance to fight back. But she only got that protection because she reached out for help and because there were lawyers who were tracking the Supreme Court ruling and knew how to use it in court. Most people in Patricia's situation do not know that this kind of help exists. Most people read the letter, feel hopeless, and either comply or suffer in silence. That is why this channel exists. I am your notification system. I am your early warning system. I am the person who translates what the courts are doing and what the government is announcing into steps you can take to protect yourself and your family. I do not want you to end up like Raymond, finding a terrifying letter in your mailbox with no idea what to do about it. Here is the final manifesto that I want you to carry with you every single day. The Second Amendment is not a suggestion. It is not a privilege that the government can take away through bureaucratic announcements and reclassifications. It is a fundamental right that is protected by the highest law in the land, and the Supreme Court has confirmed this in a ruling that the DOJ did not expect and the gun control establishment did not see coming. You have the right to own firearms. You have the right to pass them down to your children. You have the right to use them for self-defense and for the defense of your family. And you have the right to challenge any government action that tries to take those rights away without going through the proper constitutional process. But rights do not protect themselves. You have to know what they are. You have to know how to assert them. You have to know what to do when the DOJ sends you a letter that threatens everything you have worked for. The steps I gave you today are your shield. The knowledge of what the Supreme Court ruled is your sword. And the community of people who subscribe to this channel and share this information is your armor. The system is moving faster than most people realize. The DOJ announcement is already being enforced in states across the country. The trapdoors are being built right now. The gun control advocates are already designing their next move, even as we speak. But you are not alone in this fight. Every time you subscribe, every time you share a video, every time you leave a comment about what you learned and how it helped you, you are building a wall of protection around yourself and everyone you love. You are joining a community of people who refuse to be disarmed by stealth, by bureaucratic trickery, or by agency announcements that nobody asked for and nobody voted on. Do not wait until it is too late. Do not learn this information 24 hours after you needed it. Subscribe now. Stay informed. Stay ready. And remember that your rights are worth fighting for every single day of your life. The DOJ wanted you to never hear about this announcement. The gun control states wanted you to be caught off guard and forced to comply. But you found this video. You learned the truth. And now you have the knowledge and the community you need to fight back and win. Stay strong. Stay armed. Stay free.